Every click, every login, every single online transaction you make is about to be redefined. Welcome to the deep dive. Today, we're uncovering this seismic shift happening in India's digital landscape. It's the newly finalized Digital Personal Data Protection Act Rules 2025, or DPDP, as you'll hear it called. Honestly, forget what you thought you knew about online privacy. This isn't just another law. It feels like a fundamental reset, especially for, the vibrant software as a service, the SaaS ecosystem in places like Hyderabad. We've gone deep into this comprehensive guide. It's called Hyderabad SaaS, DPDP Act Compliance and Action Plan. And this document really lays out just how pivotal this moment is. So our mission for this deep dive is to pull out the most crucial insights from this new framework for you.
Exactly. We're going to clarify the obligations, pinpoint those immediate compliance priorities, and really show you why this isn't just about avoiding big fines. It's actually about building trust and gaining a real competitive edge in India's booming digital economy.
And the stakes? Well, they couldn't be higher. We're talking potentially crippling financial penalties and, of course, serious damage to your reputation if you don't comply. So for anyone operating digitally, or even if you're just curious about how your own data is handled, this is where it gets really interesting. Okay, let's start peeling back the layers here. Where do we even begin unpacking these foundational changes?
Well, you're right. The DPDP Act itself back in 2023 laid out the grand vision. But these new rules, the ones finalized and notified by MeitY, they're the precise operating manual. What's really fascinating, I think, is how they take these sometimes vague principles and turn them into very actionable requirements.
Right, so less theory, much more practical application. What's maybe one specific addition in these rules that you think might catch companies, a bit off guard? Why?
That's a great question. It's not just a minor tweak. Look at the refined consent notice requirements.
Right.
They fundamentally dismantled that old, blanket consent model. The I agree to everything button was really insightful or challenging, depending on your perspective, is that it forces SaaS companies to rethink their entire user onboarding. Like you said, no more simple I agree to terms. The rules now demand explicit, itemized, and independent consent for each specific data processing purpose.
Each purpose, separately.
Yes. So it's not just a legal checkbox anymore. It's a fundamental user experience puzzle. How do you get that granular consent without completely overwhelming the user with pop-ups and forms?
Yeah, that sounds tricky.
It is. But the companies that figure this out, the ones that make it clear and transparent, they'll build trust right from that first interaction, not just, tick a box to avoid fines. And beyond just consent, the rules have also formalized data principal rights. They lay out exact mechanisms for individuals, they call them data principals, to use their rights.
Yeah.
Like the right to erasure, getting your data deleted when it's no longer needed, or the right to correction. Your SaaS platform absolutely has to make it easy for users to do this seamlessly. And a really big point for some of Hyderabad's larger players, the specifics around Significant Data Fiduciaries, or SDFs.
SDFs, who falls into that category?
Think larger data-intensive companies. Basically the ones deciding the why and how of processing personal data. These SDFs could face extra obligations, things like mandatory data protection impact assessments, regular compliance audits, maybe even rules around algorithmic fairness. A lot of the successful data-heavy SaaS companies in Hyderabad could definitely find themselves classified as SDFs, which means a much heavier compliance load.
That sounds like a really profound shift in power, actually, giving individuals much more control. So beyond consent and data rights, what other key mechanisms are these new rules putting in place to actually make the act work day to day?
Yeah, good question. They also formalize the operationalization of the Data Protection Board of India, the DPBI.
Right, the enforcement body.
Exactly. And it's designed as a digital office. So online complaint resolution, online adjudication, all the official interactions, even breach notifications, they're all going to be digital.
Okay, fully digital. That's interesting.
And that flows right into clearer data breach notification timelines. The Act said notify, but the rules get specific. They expect notification to the DPBI and to the affected people without undue delay.
Which means?
Which is generally being interpreted as needing a detailed report within about 72 hours.
72 hours, wow.
Yeah. It demands really robust internal incident response plans because that clock starts ticking the moment you discover a breach. Now, maybe the most forward-thinking and uniquely Indian element is the consent manager framework. It gets more detail in these rules.
Consent managers, what are those exactly?
They're DPBI registered entities.
Mhm.
Think of them as intermediaries. They can basically help individuals manage their consent preferences across multiple different companies, multiple data fiduciaries.
Oh, interesting. Like a central dashboard for my permissions.
Sort of, yeah. And this isn't just another compliance task. It could actually be a game changer for SaaS scalability. Imagine offloading that complex, constantly evolving burden of managing granular consent to a specialized, certified third party.
Right. For startups, especially.
Exactly. For agile Hyderabad startups, this could seriously cut down on compliance overhead. Let them focus on their product, not just regulatory details. It's an ecosystem approach.
That makes a lot of sense. What else?
And finally, they've really tightened the screws with stricter provisions for children's data. The rules reinforce verifiable parental consent for anyone under 18. And they explicitly ban tracking, behavioral monitoring, or targeted ads aimed at kids without specific government approval.
Okay, so EdTech, gaming platforms, they need to be extremely careful.
Extremely. The definition of child is under 18, which is broader than some other places.
This really doesn't sound like a grace period anymore. It sounds more like get compliant yesterday.
Sure. But what we are seeing, is there one aspect of these new rules that's proving to be the biggest immediate bottleneck for businesses trying to catch up?
The urgency is definitely real. And you're right, the source gives Hyderabad's SaaS companies a pretty clear, actionable checklist. The absolute first non-negotiable step, a rapid data audit and mapping.
Okay, know your data.
Precisely. You have to identify all the personal data you collect, store, process, or share, especially for Indian data principles. We're talking user profiles, behavioral data, chat logs, payment info, everything. Then you absolutely have to map those data flows. Where does it come from? Website forms. Where is it stored? Cloud servers. Are they in India or outside? What about cross-border transfers? How is it processed? Analytics. Who do you share it with? Third-party tools, especially for companies with global clients, right?
Yeah.
They need to know where that Indian data is physically sitting.
Absolutely. Yeah. AWS, Azure, GCP, you need clarity on server locations. Without knowing what data you have and where it's going, well, you simply can't comply with anything else. It's ground zero.
Okay, so understanding your data footprint is step one. What's next on that critical checklist?
Second, you must review and update consent mechanisms. Like we discussed, consent now has to be free, specific, informed, unambiguous. That old generic, I agree, is just gone.
Right.
You need to put in easy ways for people to withdraw consent. It has to be straightforward, available anytime, and your systems. They have to immediately stop processing data for that specific purpose once consent is withdrawn.
Instantly.
That's the requirement. And naturally update everything, privacy policies, terms of service, in-app messages, provide those itemized details and clear instructions on user rights.
That's a huge departure from the old click and forget model. But thinking from a business perspective, doesn't getting so granular with consent add a ton of operational complexity? Could it even, put users off if there are too many choices?
Oh, it definitely presents a challenge, no doubt about it. And that's exactly why the source material really emphasizes this idea beyond the checkbox, designing for trust.
Okay.
It's about making things clear and concise, presenting those privacy notices and consent requests in plain, understandable language, not legalese. User experience meets compliance means using contextual consent where possible.
Like what? Give me an example.
Like, we need access to your location to show you nearby services. That feels much more direct and trustworthy than just a blanket ask for location data.
Yeah, that's definitely.
Offer granular options for different activities. Empower the user. And a huge point the source makes, avoid dark patterns.
Ah, those tricky UI things.
Exactly. Deceptive designs that trick people into consenting or make it incredibly hard to withdraw consent. Regulators are really watching out for those now. Now, for managing all this consent, Hyderabad SaaS firms should seriously be exploring consent managers.
Back to those intermediaries.
Yeah. Think about partnering with a DPBI-registered consent manager, particularly if you handle a lot of data.
Yeah.
They can streamline the whole process: collection, management, withdrawal. It could really cut down on your internal compliance burden.
Makes sense.
And you absolutely have to focus on managing the consent lifecycle. Keep meticulous, audit-ready records. When did they consent? How? For what purpose?
Yeah.
Which version of the privacy policy was shown?
Wow. Okay. That's detailed.
It has to be. You need systems for handling reconsent requests, managing expirations, and ensuring that withdrawal and deletion actually happen smoothly following the right to erasure. It's not a one-time setup. It's continuous management.
And what about those specific rules for children's data? You mentioned they were quite strict.
Extremely strict. Remember, the DPDP Act defines a child as anyone under 18.
Under 18, right.
Verifiable parental consent is absolute mandatory before processing any data from a child.
Yeah.
We're still waiting on exact rules for how to verify that, but it might involve things like identity checks. And there are strict bans on tracking, behavioral monitoring, or targeted advertising aimed at children unless you get specific governmental permission.
So crucial for edtech, gaming,
Yeah.
any platform with younger users. Compliance there must be spot on.
Absolutely paramount. No wiggle room.
Okay, so we've covered data audits, consent overhaul. Given all that, what are the next couple of critical action items for businesses?
Right. The third immediate action is to establish a robust grievance redressal mechanism.
Handling complaints and requests?
Exactly. Appoint a clear point of contact for data principal grievances. Larger SaaS companies might even need a dedicated data protection officer, a DPO, who has to be based in India.
Based in India, okay.
Set up accessible, user-friendly, digital channels, email, maybe in-app support, a web form for people to submit requests. And crucially, define your internal workflows. How do you promptly receive, verify, respond to, and actually resolve these requests within the required timeline?
So process matters as much as the contact point.
Absolutely. And fourth, you have to bolster data security safeguards. This means implementing reasonable security safeguards. Think strong encryption for data, both when it's stored and when it's being sent. Robust access controls, role-based access is key. Regular security audits, penetration testing, the usual best practices, but now with legal teeth. And you also need that comprehensive data breach response plan we touched on. How do you detect, assess, contain, and then notify the DPBI and the affected users within that tight timeline, likely 72 hours for the detailed report.
It's not just a tech issue then, it's organizational. Needs clear roles, practice runs.
Precisely. You need to know who does what before a crisis hits.
I can almost picture like a developer in one of those busy Hyderabad co-working spaces just staring at their screen thinking, how on earth do I rebuild our entire consent flow? Or how do I audit all this data? Beyond that immediate checklist, what are some of the unique challenges facing SaaS companies there?
Yeah, the source definitely highlights several key challenges. First off, operational integration and resource allocation. Hyderabad's startup scene is famous for being agile, moving fast. That can sometimes clash with the, let's face it, burden of compliance.
Right, slows things down potentially.
It can. Integrating these DPDP requirements into agile development sprints, especially if you have smaller teams, that's a significant undertaking.
Yeah.
This is where that concept of privacy by design becomes so important, embedding privacy considerations right from the start of product development, rather than trying to bolt it on later, which is always more expensive and difficult. And then there's the actual costs, maybe new compliance tools, legal advice, potentially hiring or appointing that DPO. It adds up. Another big challenge is vendor and third-party management.
Ah, the supply chain.
Exactly. SaaS companies rely heavily on third-party services, right? Cloud hosting like AWS or Azure, analytics tools, payment gateways. Any vendor that processes personal data of Indians on your behalf becomes a data processor under the Act. So you have to go back and revise your contracts, your data processing agreements, DPAs. They need explicit clauses covering security, breach notification, helping you with data principal requests.
And you need to check they're actually compliant themselves.
Yes, due diligence on your vendor's compliance is essential because ultimately the data fiduciary that's you, the SaaS company, remains accountable. The buck stops with you.
So even if you outsource parts of your operation, the core responsibility, the liability stays firmly with you. That's a huge weight.
It absolutely is.
Yeah.
Then there's data retention and erasure timelines. The Act really emphasizes purpose limitation. You should only keep data for the specific purpose you collected it for and no longer than necessary.
So no more hoarding data indefinitely.
Correct. That's out. Businesses need clear data retention policies and robust processes for managing the data lifecycle, ensuring timely, secure deletion or proper anonymization of data when it's no longer needed. And finally, there's the potential classification as a significant data fiduciary, SDF, that we mentioned earlier.
Right, the higher tier.
If your Hyderabad SaaS business gets classified as an SDF, you face those increased obligations. Appointing an India-based DPO, doing mandatory DPIAs, undergoing independent data protection audits. Many rapidly scaling SaaS companies could easily meet the criteria for becoming an SDF, which dramatically escalates their compliance requirements and costs.
Okay, this all sounds like a pretty monumental task, especially, as you said, for the agile Hyderabad startup scene. But I'm really intrigued by this idea that it's not just about avoiding the stick, it's about seizing an opportunity. How can a smart, forward-thinking SaaS company in Hyderabad actually turn this compliance burden into a genuine competitive advantage beyond